welcome to the Arbitration Conversation. So in this webisode, we're going to have a special treat to discuss sports arbitration with a true leader in international sports arbitration who has worked in a lot of different aspects with the Court of Arbitration for Sport, as well as FIFA arbitration, as well as basketball arbitration. So a really wide range of areas that he has been working in. So his name is Cliff Hendel, and he is an international arbitrator. He has his own international dispute resolution firm. He's based in Spain, but he has worked in all over the world and is a U.S. trained lawyer. Cliff, thank you so much for being here.
It's my pleasure, Amy.
So maybe just to start off, if you could give a little bit of information in terms of how does one become such a leader in sports arbitration, an area that many would aspire to be part of just because it's exciting, it's sports. So how did you get to where you are today?
By happenstance, actually. I was a transactional lawyer for the first half of my career in New York and Paris, essentially. I came to Madrid and began to work at a small firm. And one day, an opportunity to be counsel in an international commercial arbitration arose. I accepted the opportunity, had a lot of fun with it. The hearing was at the ICC Hearing Center in Paris. And during a coffee break, the ICC counsel came up to me, told me he was interested in my background, my profile, because I was bilingual and admitted to practice in New York and in Madrid, that I lived in Spain, and that I didn't have a Spanish passport. And the fact that I didn't have a Spanish passport was important to him because he was looking, they were always looking for non-nationals in order to sit as sole arbitrators or chairs of tribunals in particular countries. And in Spain, Spain is not London. Madrid is not Paris or Geneva. The international legal community here is small. So when he found that there was a non-Spaniard who was able to function in Spanish law and in Spanish, he was very happy to consider me. He asked me, would you mind if we considered you as arbitrator in appropriate circumstances? I said, feel free. And very quickly, the ICC began to name me as arbitrator, and I liked it. And this was around 2008. There was a financial crisis. My practice, which was financial and M&A related, my firm's practice, began to evolve a bit. We began to have more disputes and less commercial work. So it was rather easy for me. Also, my firm was a very small firm, and I was able to reinvent myself over time and move from one area to another. So I began to get very active in disputes as counsel in arbitration and as arbitrator, but this is commercial, not sports. But once I was in the commercial arbitral world, I had my eyes and ears open, and I saw that there was something called the Court of Arbitration for Sport. I had no idea what that was, but one day they came to Madrid to present themselves, and I showed up, and it seemed very interesting. And they said that, of course, they're looking for sports experts, but they're also always looking for commercial arbitration experts, a certain number of them, to have the international expertise sort of in the pot, as well as the sports expertise. In my case, they said that they would be interested in my candidacy, and that every year they expanded or renewed the panel, and I should apply, which I did, and I was admitted. And then, and all of this takes time, of course, I began to receive cases, and more cases, and more significant cases. That's how I became a sports arbitrator. I'm still a commercial arbitrator, and I still do counsel work. And in fact, I do more commercial work than sports work, but I do a lot of sports work. And I've started, you might say, at the top. The Court of Arbitration for Sport is the Supreme Court of International Sports Law. But on my very first case, I met the people who were just setting up an independent arbitral tribunal under the auspices of the FIBA, which is the International Basketball Federation. And I said, gee, that's interesting. How does this work? Well, we have 5 arbitrators. We're just getting started. We think it'll be a successful initiative because we have some features that are, we think, more efficient, more speedy, more user-friendly, more arbitrator-friendly than some of the other institutions. Sounded terrific to me. And I said, well, if and when you expand, let me know. Many years later, perhaps 7, 8 years later, just when I decided to set up my own shop, in fact, they called me. They were looking to expand from 7 to 8 arbitrators. And since the past 2 years, I've been an arbitrator, very active with the FIBA. It's called the Basketball Arbitral Tribunal, the BAT. Perhaps we'll talk about that in a few minutes as well. But it operates in a very special and a very efficient way. And I've had a lot of fun with that.
Well, I really wanted to hear, I wanted to explore that a bit further because that is something that I knew, of course, about the Court of Arbitration for Sport and with the FIFA arbitrations and dealing, of course, with soccer and some other sports. But I wanted to hear more about the basketball BAT and how that works in the sense of, number one, what kind of disputes do they handle? I mean, what sort of disputes do you generally see in that tribunal?
We see only contract disputes, essentially labor disputes in international basketball, international other than the NBA, which of course, as in everything or almost everything, US sports is different. American exceptionalism thrives in the world of sports. But in the world of international basketball, virtually all federations, virtually all professional leagues, their contractual disputes are potentially subject to BAT jurisdiction if the parties agree. There is no adhesion or no implicit acceptance as there is in general in the CAS, Court of Arbitration for Sport world, or in the Olympic movement world, where, for example, if you want to participate in the Olympic Games, you have to sign on to an arbitration clause. You're not literally forced with a gun to your head, but if you want to participate, if you want to ride in the Tour de France, you have to accept arbitration. This is an issue which from time to time raises legal issues. In general, in the world of international sports, it's been accepted as, let's say, a necessary evil. In the world of the BAT, on the other hand, there is no adhesion or no implicit acceptance. It's simply the parties agreeing. But the parties have agreed.
And is it that do they tend to agree? I mean, do we see a lot of players?
We have more than 200 cases a year in an institution which is less than 10 years old. And as you know, arbitral institutions take time to get settled, for their market to acclimate.
Oh, yeah. Yeah, that's really interesting. And I guess the other question becomes, which comes up all the time in international law, we ask, what law applies? So when you deal with these cases in the tribunal,
well, that is one of the very interesting features of the BAT.
As an arbitrator, what law do you?
The law that we apply in the BAT is equity, not law. Why? And what does it mean? It doesn't mean equity in the common law sense, in which there used to be a separate body of law, a separate court system. And then one day that was merged with law, and now we have law and equity, and it's all rather confusing to common law lawyers, at least to this one. Equity in a continental sense, and we were using the term in the Swiss law sense, essentially means applying the contract under the circumstances of the case and modifying the contract if one believes that the circumstances are such that the contract should be modified. But essentially, equity in the world of the BAT means pacta sunt servanda, the contract, subject to potential modification in limited areas. Why do we do this? I say we. I was not there when the BAT was formed 10 years ago, but the decision to use equity was not was a rather creative and perhaps even a risky choice, because people don't know what it means. People understand what law means, but the problem is the BAT was looking for speedy and efficient resolutions, and they were not looking because there were too many disputes in international basketball. The American player who goes to China, the Serbian player who goes to Turkey. There are, more important cultural problems here, language problems, the risk of signing someone for high value and then not complying and not paying in full is rather high. These things were happening in the world of international basketball, and the FIBA was saw it as dangerous and damaging to the future of international basketball, which has become, by the way, the second most important world sport beyond, aside, far
After soccer.
Soccer, of course. And they wanted to find a way to solve these disputes quicker, faster, and better. And the decision to use equity was one of the features that was chosen. But the reason for it was to avoid the need to have to go to the local law of dozens or hundreds of different countries.
Absolutely.
And ask for a legal opinion about social security law of Poland or of Turkey, and then contrast that legal opinion with another, and then maybe bring the two experts to a hearing and interrogate them. The idea of the BAT was to speed things up, doing it through sole arbitrator cases, through cases in general decided online, on the papers, online, without hearings. Hearings are not prohibited, but hearings are rare. And if a party insists on a hearing or wants a hearing, the party has to pay a little bit more for it. Those are the rules. It's an unusual rule, but it works.
That is.
And the result is we have been, and again, I say we, the BAT has been very successful and is now being viewed as a kind of model for other sports arbitral bodies.
Well, and we've seen this idea of using equity in other areas as well, because of exactly what you talk about in deciding otherwise what law would apply. The question, and then I would assume that these are binding awards that are enforceable under the New York Convention, correct?
Yes, of course.
So,
but they are also, as with most sports awards, they're also enforceable by the federation in question, in this case the FIBA, so that if a club, for example, loses a case and has been ordered to pay a player a certain amount of money, the New York Convention is there. But the effective enforcement mechanism is that FIBA itself will take that club, and if they haven't paid within a certain amount of time, it will sanction that club. It will, for example, impose a transfer restriction, a registration restriction, so that the club is not able to bring in new players. So it's and this works in the football world as well. These are self-contained, let's say, enforcement mechanisms, so that you don't need the New York Convention generally to get your award enforced.
Well, and that, I'm sure, again, adds to the efficiency, because you know that enforcement is easily had, right? And so you don't have as much litigation about the arbitration,
exactly.
Which can occur sometimes in commercial arbitration.
Exactly. Also, the stakes, the monetary stakes, tend to be smaller. There are occasionally huge cases, but generally there are small cases. To take the case to the Swiss Federal Tribunal, involves cost and time that rarely is justifiable in a sports case involving a labor contract. As I say, in the BAT we deal with contract disputes only. We don't deal with corporate governance issues. We don't deal with doping issues. We don't deal with a whole range of issues which can come up in the sporting context and are dealt with by other sports arbitral bodies like the CAS. And some of those any case which involves your ability to earn your livelihood, a sanction, a suspension, that is a kind of case where you might want to take it up to higher levels and take it, the case to the Swiss Federal Tribunal. But generally, in a contract case, that's very unlikely to happen.
Wow, well, that's really interesting stuff. I guess the last final question really then is, when you think about the different tribunals and different processes you've worked in, right, dealing with FIFA, dealing with Court of Arbitration for Sport, dealing with BAT, is there one process you'd say is the best or runs most smoothly, I would say, in terms of process, pure process?
I would say only that they're all different. The CAS is a more staid, sober, traditional body where things occasionally move slowly and perhaps ponderously, but can move very quickly when they need to. But there we have panels of three, generally distinguished, very experienced sports arbitrators who are fine arbitrators and very knowledgeable in the sporting world. Dealing with a whole range of disputes, as I say, not just contract disputes, but generally dealing with any appeal from any international federation. Football maybe accounts for 50% or so of the case work at the CAS, but it's not only the contract disputes that I've described at the BAT, or the contract disputes that I deal with at the FIFA, where since last year I've been deputy chairman of something called the DRC, the Dispute Resolution Chamber, which is the internal judicial organ. It's sometimes referred to as an arbitral organ. It's really an internal judicial organ versus an independent arbitral organ, which is what the BAT is. But internally, it resolves with a large staff of internal lawyers by panels of three, including one neutral, which is me, one representative of labor, one representative of management. We decide on average 800 or 900 cases per year. So 15 or 20 cases per panel per month. This is a very fast track kind of procedure where the CAS is always available and occasionally resorted to revise, perhaps with more care, the decisions that we've made at the level of FIFA. So I don't, I'm not able to compare and say one is better than another. What's interesting is that they are all very different. It's a kind of horses for courses. I think the BAT model has worked very well in the world of basketball, and I know it's being looked at in other sports as a potential model as well. And I think the CAS as well, which operates at the very pinnacle of this world, it doesn't have the same, let's say, competition that a commercial arbitral institution might have. The ICC is also at you might say, the pinnacle of the commercial world, but it competes every day and has to with lots of other bodies. And if those other bodies innovate and come up with an interesting idea that's practical, that's efficient, that's quick, that makes the clients happy, the users, that makes the arbitrators happy, the ICC should think about that, and vice versa. The CAS doesn't have that direct competition, and therefore is perhaps a little bit slower to evolve, but it too is evolving. And I think what's interesting is to see how within the sporting world, and also between the sporting and commercial world, there is a kind of crossing of experiences, of practices, so that things evolve, don't stagnate, but evolve and improve in the interest of the users. That's, in the end, that's what we're all about.
Well, exactly. I mean, I think what this conversation has really highlighted, right, is how you have to fit the forum to the fuss. And the right process for one type of dispute, it might be different type of process because it's a better process for resolving problems in that particular context. And we see this from the tribunals that you've discussed. Well, Cliff, this has been fantastic. Thank you for taking this time today. I
My
really,
pleasure.
really thank you for this information.
Well, it's my pleasure, Amy.